Jefferson County Court of Law number 2 is back in session. Court is in session in two cases, cause number 331938 and cause number 331940. Both cases are styled the state of Texas versus Jacory McCulley. Mr. McCulley, is that your full name?
Yes, sir.
Mr. McCulley, would you please raise your right hand? Mr. McCulley, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
I do.
Mr. McCulley, you may put your hand down. How are you doing, Mr. McCulley?
How about you?
I'm doing fine. Thanks for asking. Mr. McCulley, you're here represented by your attorney, Attorney Todd LeBlanc. Attorney LeBlanc, how are you doing?
Good.
Mr. LeBlanc, do you waive a record in Mr. McCulley cases?
We do, Your Honor.
Mr. McCulley, in cause number 331940, I have before me an information that was filed by the Jefferson County District Attorney's Office. This information alleges that on or about January 13th of 2022, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest, detention. Mr. McCulley, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. McCulley, how do you plead? Guilty, not guilty, or no contest?
You.
Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. McCulley, I also have before me a document that is titled Misdemeanor Plea Admonishment. Do you recognize this document?
Yes.
Now, on page 2 of this same document, Mr. McCulley, there is, well, there are a set of initials on the line that's checked guilty. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And Mr. McCulley, on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the document?
Yes, sir.
Now, and that your signature is above the line that is titled defendant, is that correct?
Yes, sir.
I also have before me, Mr. McCulley, a document that is titled Discovery Certification. Do you recognize this document?
Yes, I do.
And is this your signature? And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. McCulley, before you signed and initialed all of these documents that I've just mentioned to you, did your attorney, Mr. LeBlanc, go over these documents with you?
Yes, sir.
And did you read and understand everything that Mr. LeBlanc went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. McCulley, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit number 1. State, you like to offer State's Exhibit number 1 in the evidence?
Yes, Your Honor. State offer stage one.
Any objections?
No, Your Honor.
No objections. State's Exhibit number 1 is admitted. Mr. LeBlanc, you have advised and counseled Mr. McCulley. Is there any evidence that he is mentally incompetent to stand trial?
None that I'm aware of, Your Honor.
Mr. McCulley, your attorney, Mr. LeBlanc, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. McCulley, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
Your Honor, in exchange for the defendant's plea of guilty in this case, the state is recommending confinement in the Jefferson County Jail for a period of 90 days, Your Honor. We're asking that the court suspend imposing that sentence at this time and place the defendant on community supervision for 1 year. Your Honor, required defendants to pay a $500 fine and to complete 40 hours of community service. Lastly, Your Honor, in connection with this plea agreement, the state will be moving to dismiss companion case number 331938. Agreeing to forfeit the weapons found, which was a large D2C pistol, serial number 88N168357, and I have a motion for forfeiture.
Thank you. Now, Mr. McCulley, the state is offering that you serve 90 days in the Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail on this case because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $307, which comes to a total of fine and court costs of $807. You'll also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You will also be required to reimburse Jefferson County the court-appointed attorney's fees of $250. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $175 a month. Will you be able to pay the $175 each month? You will also be required to perform 40 hours of community service. You will also be required to adhere to the other standard terms and conditions of this probation. The state will be dismissing cause number 331938 for forfeiture of the weapon, and I have before me a motion to forfeit this weapon. Mr. McCulley, do you recognize this document?
Yes, sir.
And is this your signature on the document agreeing to forfeit the weapon to the Beaumont Police Department?
Yes, sir.
Now, prior to signing this document, did your attorney go over this document with you?
Yes, sir.
And did you read and understand everything in this document?
Yes, sir.
And is everything in this document true and correct
Yes,
to the
sir.
best of your knowledge?
Yes, sir.
Mr. McCulley, I will grant this motion to forfeit this weapon to the Beaumont Police Department. And Mr. McCulley, do you? Mr. McCulley, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yeah.
You do? Mr. McCulley, I will follow the plea bargain agreement that you have entered into with the state. Mr. McCulley, this will conclude your case. You're going to stand on the X next to your attorney, follow the directions of our clerk. Once you finish following her directions, after you receive a copy of your dismissal, you'll be free to go and you have a blessed day.
Yes, sir. Thank you.
Hi, Mr. McCulley. Can I get your right thumbprint on that blue light in front of you, please? Thank you. You can remove your thumb.
Thank you.
All right, now, Mr. McCulley, can I get your signature on, hold on, let's take a second. Okay, here, can I get your signature, please? You won't be able to see it, but I will. Thank you. And Mr. LeBlanc, can I get your signature? Thank you. Now, Mr. McCulley, one last thing. Can I have you raise your right hand? Do you swear that you never will forward your probation or deferred adjudication for a felony or misdemeanor in Texas or any other state? Okay, and you have no other pending charges that you're aware of. So here's your paperwork. This is my report that this after was going to leave, and I've attached everything on your paperwork.
So when I leave out of here,
Yes, sir.
Yeah, you go between those tables. Mr. Bailiff, would you turn the camera around? Oh, he need an excuse?
Yeah, just go out, you know, you check in at by the receptionist area, she could get you.
You can go have a seat. Court is in session in cause number 328-325, case of style of state of Texas versus Cody James Patterson. Mr. Patterson, would you please have a seat at council's table? Court is in session and cause number 328-325. Case is style of State of Texas versus Cody James Patterson. Mr. Patterson is present in court with his attorney. Mr. Wright Kimler, the state is present with Assistant District Attorney, Attorney Tommy Coleman, and Attorney Lamar Johnson. Also is present, Attorney Raymond Shearer. Court reporter is present. State, are you ready? Defense, are you ready? Mr. Bailey, could you please call the jury in? And Mr. Paget, you're excused. That gentleman right there. Let's see, 1, 2, 3, 4, 5. Nobody should be there. That's number 6. Soko should be in 7 in that middle seat. Your name Graham? That's name Graham, okay. No, he's number 9. Graham is number 9. And then number 10 is gonna be blank. And then after number 10 is Andrews. That's Andrews right there. And then 12 is, yeah, the first 12 is it Alexander? Who is 12? That's you? Okay. Yeah, you're in the right spot. You're in the right spot. So that's Jarrell. That's you.
Gerald.
Gerald. Welker.
Yes.
That's you. Wolf. And Ferris. Okay. Just want to make sure everybody's in the right seat. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You will be examined for inclusion on a criminal jury trial. Our court hours are normally from 9 a.m. to 5 p.m. However, in this court, because we have large dockets in the morning, you'll be asked to come, if you're selected, to come back to court at 1:30 in the afternoon. Whether you're selected as a juror today, you are performing a significant service which only free people can perform. If you are selected, you will be tried, this case will be tried expeditiously with justice, which requires a careful and impartial trial. I must first administer to you the first of 2 oaths. I need each and every one of you to raise your right hand, and then once I've administered the oath, I need every one of you to say, "I do." Would you please raise your right hand? Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under the directions touching on your service and qualifications as a juror, so help you God? Okay, you may put your hand down. The law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on a criminal jury trial. It is very important that you answer these questions truthfully. If you do not, and the lawyers and I discover this fact after you have been seated on a jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. Now I'm going to ask you a series of questions, and the way I will do it is I will ask the questions, but I do not want you to answer out aloud. I just need you to answer to yourself. And then once I finish asking all of the questions, I would then ask if anyone disqualified under the law. And if you think that you may be disqualified under the law based on your answers, then I will ask that you will come up before the bench so that we could discuss the matter more privately. And the way we will do it, we'll turn off the mics and we'll use this device so that no one will be able to hear. Okay, does everyone understand? Okay, first question. Except for failure to register, are you a qualified voter in this county and state under the Constitution and laws of this state? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony. And then I usually pause on this question to explain to you that this is a question that I have to ask by law. And the question is as follows. Are you presently insane? Or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a pettit juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? Is anyone disqualified under the law? If you think you may be disqualified, just please raise your hand. Okay. We have 2 people. This is juror number 9 and juror number 14. Mr. Graham, would you please come forward? Court is back in session and calls number 328-325. Case of style of state of Texas versus Cody James Patterson. After the discussion, the court, all the jurors are qualified. We will now move on to exemptions. Now, ladies and gentlemen of the jury, I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just please continue to remain seated. And these questions will be asked in the same manner that I asked when we was determining whether or not you were qualified. And so please answer the questions to yourself. And then at the end, I will ask you if any of these exemptions apply to you, and if you would like to claim any one of these following exemptions or not. First question, are you over 70 years of age? Do you have legal custody of a child or children under the age of 12 years and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in this county during the 3-year period preceding the date you were asked to appear here today? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States military forces serving on active duty and deployed to a location away from your home and out of Jefferson County? If any of these exemptions apply to you and you do not desire to serve as a juror, please raise your right hand. Let the record reflect that no one on the panel have raised their right hand. Now we will move to excuses. If any of you feel that there is a reason why you should not sit as a juror, once I finish explaining the excuses to you, we're going to ask that you raise your right hand and then come up so we can discuss the matter outside the presence or outside the hearing of the other members of the panel. A juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the state and the defense. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone here who wish to claim an excuse? Please raise your right hand. Let the record reflect that none of the members of the panel have raised their hands. Now, ladies and gentlemen, we will move to the voir dire portion. Let the record reflect that the defendant, Cody James Patterson, is present with his attorney Attorney Rife Kimbler. And let the record also reflect that the state is present with Assistant District Attorney Tommy Coleman sitting first chair and Attorney Lamar Johnson sitting second chair. Also, we have in the jury box, we have Raymond Shear, who is also an Assistant District Attorney. Ladies and gentlemen, you have been summoned to this court as prospective jurors in a criminal case. The defendant, Cody James Patterson, is represented by his attorney, Attorney Rife Kimbler. The state is represented by Assistant Criminal District Attorney, Attorney Tommy Coleman, and Attorney Lamar Johnson. The court reporter is Ms. Ada Christie. She will be taking down everything being said. So speak up when you are answering or asking questions. The defendant stands charged by information with the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. The range of punishment for this charge for a Class B misdemeanor DWI is confinement in jail for at least 72 hours, but not to exceed 180 days, a fine not to exceed $2,000 or both such fine and confinement. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we may discuss it more privately. Is the state ready to proceed?
State's ready to proceed, Your Honor.
The panel is yours, Mr. Coleman,
Thank you, Your Honor.
and I will be keeping time.
5-minute warning.
Okay, you have 30 minutes.
Good afternoon, everyone. My name is Tommy Coleman. I'm one of the assistant district attorneys here in Jefferson County, and I want to begin by thanking you for your time and attention this afternoon. I know this is probably not the place that you would want to be, but I suspect that if you were in this defendant's shoes and you were accused of a crime, you would want jurors or potential jurors to be here with their undivided attention and not thinking about the things that they can be getting done at work or the tasks that they can be doing around the house. And I know that that would be the case for me. I want you guys to get full attention, and I suspect it will be the same for you. What I will do, what I promise you, is if you'll engage me in a discussion, answer my questions honestly, and in a back and forth, then I will not waste a minute of your time. I'll do my very best to get through this in less than the 30 minutes that the judge has allotted me. If you promise me that you'll answer my questions honestly, please raise your hand. For the record, everyone has raised their hand. From time to time, I'll be making statements like that. I'm not just talking to myself. I am making sure that the record has been taken down by the court reporter reflects the fact that certain people raised their hand or didn't raise their hand. I'll refer to you. I'm not trying to be cold about it, but because I refer to you by your juror number, because again, we want to make sure we keep the record straight. There's one thing I neglected to do is to tell you about a little bit about myself, because I think it's only fair, given the fact that I've gone through your jury questionnaires. I know a little bit about each and every one of you. Mr. Gidry, I know that you worked for the United States Post Office, right? Mr. Graham, you're an engineer. Ms. Bogarini, The only reason I know how to pronounce that is because they're debating, so it's how to pronounce that. I know that you're a teacher. So, and a consultant, Mr. Solko, your consultant. So I think it's only fair that I just tell you a little bit about myself. But for the time that I've spent in the United States Army, I've lived in Texas all my life. I grew up in Dallas. I went to undergrad in Fort Worth at Texas Wesleyan University and law school in Houston at South Texas College of Law. And since graduating in 2000, I have been a prosecutor for the majority of my career, and I do enjoy being a prosecutor. Contrary to what some people think, my job is not to convict people. My job is not to send people to jail or prison. My job is to find justice, is to seek justice. And that's what I want in this trial, for this defendant. I want 6 of you who will determine what justice is in this case. Do you follow me, Mr. Alexander? Very good. So with that being said, I cannot talk about the facts of this case. But what I can say is this case is a DWI case, a driving while intoxicated case. And the law on driving while intoxicated cases is that you can commit that offense by being in operation of a motor vehicle. Can you hear me in the back row back there? I feel like sometimes I'm yelling at these people in the front row. I'm gonna try to make sure you hear me in the back, but Mr. Randall, Mr. Quinn, Ms. Jackson, if you guys can't hear me back in the back, at any point, just raise your hands and let me know. Sorry for you guys if I'm yelling at you, but I want to make sure that they hear. But at any rate, chapter 49 of the Texas Penal Code says that if you are operating a motor vehicle and you are intoxicated and you're operating that motor vehicle in a public place, then you're guilty of the offense of driving while intoxicated. It's not complicated, Mr. Andrews. You follow me? Operating a motor vehicle in a public place while intoxicated. Does anybody have an issue with that law or what we call the elements of the law as you break them down? From time to time, I get people, potential jurors, Mr. Foster, who will say they don't disagree with the law. You know, for instance, with the marijuana laws, there are a lot of people nowadays who want to decriminalize or legalize marijuana, and I get it. You know, if you disagree with the law, now's the time to tell me this, because once you become a juror, if you're selected to be a juror, you're obligated to follow the law, regardless of whether or not you agree with it. Are you with me, Mr. Johnson? Then now's the time to tell me if you've got a problem with the law as the legislature has enacted. Because once you're in talk with your guy, now especially. All right. All right. So this is not a marijuana case, it's a DWI case. I have yet to have someone say that we don't need a law that prohibits driving while intoxicated. But I don't know, this may be the first time. Please raise your hand if you think that that's a stupid law, that we should not have a law that says it's illegal for you to operate a motor vehicle while driving intoxicated. I mean, because think about it, Ms. Gerald, Gerald. I mean, what's the obvious reason why we have a law against driving while intoxicated? People die. That's right. It's dangerous. Motor vehicles, as much as they weigh, as fast as they can drive, can be operated, they pose a danger. When you agree, Mr. Wilbur, to the public. That's what we have. Plain and simple. Anybody have anything to add to that, or you want to discuss as it relates to that particular law? For the record, nobody has raised their hands. They want to talk about the elements of driving while intoxicated under chapter 49 of the Texas Penal Code. Now, I'll tell you where it kind of gets a little dicey, Mr. Guidry. It gets a little, sometimes the area is kind of muddied up or gray, is the manner and the method in which someone can be intoxicated. The law says that a person can be intoxicated by if they don't have the normal use of their physical faculties, if they don't have the normal use of their mental faculties, if it can be shown that the reason that they don't have the normal use of their mental or physical faculties is due to the introduction of alcohol or drugs. Okay, that's one way, loss of normal use of your physical or mental faculties by reason of introduction of alcohol or drugs. And then the other way, Mr. Dendy, is for a person to have a blood alcohol concentration of 0.08 or greater. The law says if you got a 0.08 or greater blood alcohol concentration, boom, you're presumed to be intoxicated. Okay, so there's a 0.08 presumption, and then, Mr. Gidger, there is the loss of normal use of your mental or physical faculty because you ingested alcohol. Does anybody not follow me on those two alternate ways of proving intoxication? Okay. I mean, let's see who I not talked to. Mr. Sokol, I mean, you've seen individuals, perhaps at a party, in a social event, who perhaps have had too much to drink, and maybe they are no longer in control of their normal use of their physical faculties or normal use of the mental faculties. Can you think of an example that would show, that would indicate someone no longer has the complete control of their mental faculties? That's right. That's right. Well, I would submit to you that goes for the physical faculties. You know, that's an outward physical manifestation of perhaps someone who doesn't have their complete control of their physical faculties. What about mental? Can you think of an example? I know I put you on the spot. Slurred speech. Slurred speech, again, I would go with mental faculties. How's about this? Let me throw you an obvious softball here. What if they get ready to leave and go home and they're looking for their car keys, but the car keys are in their hand? You know, I would submit to you that perhaps that is an example of someone who has lost the normal use of the mental faculty. They don't even realize they've got the car keys. Okay. Mr. Graham, what do you think? Can you think of any other examples of a person who may have lost the normal use of their mental faculty? We're not remembering something, maybe something that they would ordinarily remember. They're homeless, you know, they lived with that address for years, and now they're having trouble calling their home. Anybody else, Mr. Foster? ABC. Yeah, that's a perfect example. You know, we all learned our alphabet in elementary school, you know, and ordinarily, if you're not intoxicated, if you haven't lost the normal use of your mental faculties, you can recite them. I can't say it backwards. I've heard people say it backwards. ZA. My point is, yes, if you not being able to recite your alphabet, the ABCs, lost the normal use of your mental faculties. Mr. Sokol, you got ahead of me on the physical faculty, so I'm not going to spend a lot of time on that. But loss of balance, slurred speech, those are indicators of a loss of of physical faculties. These are indicators that juries across the country, day in and day out, evaluate if there's evidence of these indicators. They evaluate as to whether or not an individual has lost the normal use of the physical mental faculty. Is there anything, Ms. Gerald, about that? Can you follow me? Is there anything that you want to add, or any other examples before I move on? Remember our promise, you talk to me, you answer my questions honestly, and I'll keep on moving. But if I kind of pull it out of you, it's gonna take a lot longer. I have talked to you, Ms. Phipps. What do you think about this whole business of losing your normal use of your faculties, or your mental faculties or your physical faculties? What do you think about that?
I guess someone who can't walk well.
Yeah, stumbling around.
Yeah.
Yeah, if they don't normally stumble around, yeah, that's an indicator. I think I've probably gone over this as far as I need to go. I'm not gonna continue, I'm not gonna be a dead horse on this, but one way to prove up intoxication, that's gonna lead with this, is loss of normal use of your physical faculties or mental faculties. The law doesn't say you have to be falling down drunk, Mr. Wolf. You don't have to be passed out. The law doesn't say that. The law simply says if you've lost the normal use, some use, a use of your physical or mental faculty, then that's enough to get you there if the jury believes it beyond a reasonable doubt, okay? And we'll talk about beyond a reasonable doubt here in just a second. Now, we also, Mr. Denby talked about the alternate way of proving intoxication. That's having a blood alcohol concentration of 0.08 or greater. The law says, regardless of whether or not you can show that a person has lost the normal use of the physical mental faculties, regardless if you show they're stumbling around, have slurred speech, can't say the ABCs, if they have a 0.08 blood alcohol concentration of greater than, then they are presumed to be intoxicated. What do you think about that? Fair or not fair? I mean, that's what the legislature said. I mean, again, like we talked about, now's the time to say, for you to say, you know what, I think the legislature got it wrong. I think it should be higher, or I think it should be lower. I mean, in the reverse of that. I mean, Ms. Randall, you're nodding your head. I mean, what do you think? I mean, I'm not saying you're a scientist or you've done the research on this matter, but if the legislature says having a 0.08 blood alcohol concentration is good enough to show that this person is intoxicated, what do you think about the legislature's setting that bar?
I think it's right. I mean, my religion is different. I don't drink, but I have family that does, and I prefer them to stay home.
And I'm sure a lot of people share that sentiment, but I want to clear something up, and I'm sure Mr. Kimler, when he gets his opportunity, will probably touch on this as well. The law is not that you can't drink and drive. The law is that you can't be intoxicated and drive. And again, two ways that we show the intoxication is having the loss of your normal use of physical mental faculty, or having a blood alcohol. I mean, Ms. Johnson, why do you think that's important when you're operating a motor vehicle? You're in a let me give you this scenario. You're in a residential neighborhood. There's toys and balls bouncing through the neighborhood. It's around 3:30, 4 o'clock. You're driving through that neighborhood and you're intoxicated, and you don't have the normal use of your physical mental faculties. What is the risk that is posed? So I can get her potential child with the residential neighborhood. So that's what it's at stake. And Mr. Randolph kind of went off took a little left turn there. But the point is, the law doesn't say that you can't drink and drive. The law simply says that you can't be intoxicated. And to bring this thing full circle, we demonstrate intoxication as prosecutors by proving to the jury beyond a reasonable doubt that one of two things: they've lost the normal use of the physical mental faculties, or they have a blood alcohol concentration, one or the greater. Everybody with me on that? You know, trials in Texas are separated into two portions. There's the guilt innocence phase, and then there's the punishment phase. And the defendant can elect to have the jury assess both, or determine both guilt and innocence, and assess the appropriate punishment. Or they can say, I want the jury to determine whether or not I am guilty, and I will ask the judge, the court, to assess the punishment. It's my understanding that the defendant has elected the court. So my question to you is whether or not, knowing that if you believe beyond a reasonable doubt the defendant is guilty, and if you find him guilty, that you can do so knowing that someone else, the court, the judge, will be assessing punishment. Is there anyone who has a problem with that? From time to time, I have people say, you know what, if I find somebody guilty, I want to have a say-so, a hand in the type of punishment that they face. Anybody, raise your hand. You need to assess both guilt or innocence and the punishment. Nobody's raising their hand. And I just want to reiterate the punishment range here. Nobody's going to prison if they're found guilty of this offense. It's not a felony offense. It's a misdemeanor, class B misdemeanor, punishable by up to 6 months in jail, anywhere from 72 hours in jail in this case, or up to 6 months in jail. A fine of anywhere from $1 up to $2,000, and probation. Probation is an option if a person's eligible for probation. I just want to make sure that you're aware that that's the full punishment, even though the defendant is elected for the jury to determine punishment. How do we get there? How is a jury supposed to determine guilt or innocence? Well, the standard in Texas is beyond a reasonable doubt. The standard in Texas is not like they say on TV, beyond a shadow of a doubt, or whatever that is. But it's beyond a reasonable doubt. And there is no definition of what beyond a reasonable doubt is, okay? Beyond a reasonable doubt is something that's individual to each and every one of them. I submit to you that, well, yes, Mr. Well, what's the only way for you to know that something happened with 100% certainty?
I experienced it myself.
You experienced it yourself. Either it happened to you or you were there on the scene as a witness. And the law recognizes that if in that instance, you wouldn't be a juror, you'd be a witness, and I'd be calling you to testify, or you'd be a victim in the offense. And I'd be calling you a victim. So given that, the law recognizes that you don't, it doesn't hold me to the standard of proving my case with 100% certainty. It says, Mr. Alexander, all we have to do is prove our case beyond a doubt that is reasonable. I mean, unless, like Mr. Welker said, you were there on the scene, you're not gonna know with 100% certainty. I would submit to you that, I mean, there could always be some doubt, there could always be some excuse or some reason. Aliens came down and inhabited somebody's body and took them over and made them commit the offense. But I would submit to you, you ask yourself in your heart, in your gut, if that doubt is reasonable. Is there anybody here who would require 6 nuns to come in and testify about this? DNA, like they see on TV, get DNA off of everything on TV. Or who would require satellite photos? I guess what I'm getting at, and I'm not trying to minimize the seriousness of this, I'm being a little tongue in cheek here, but what I'm getting at is the law, Mr. Quinn does not require us to prove our case with 100% certainty, okay? And so this is important, and I want to make sure that you understand it and that you agree with it. Is there anybody here on the first row, Mr. Denby, Mr. Foster, Mr. Gidry, who would require me, prosecution, to prove this case with 100% certainty? Okay, for the record, no one has raised their hand or indicated that they would be. Anybody on the second row, Ms. Johnson? Ms. Johnson, right? Got it. Rosemary, Ms. Johnson, Mr. Soko. Are you guys the only people on the row? Wow. Would either of you require me to prove my case with 100% certainty? No? No? The two of you seem a little uncertain. Well, either yes or no. I mean, would you require me to bring you 100% proof of the defendant's guilt or innocence? Or could you make a determination as to whether or not, if there's any doubt, that doubt is not a reasonable doubt? Okay, I don't like putting people on the spot, so I'll move on. What about you, Mr. Soko? Do you follow my question?
We'll follow the definition of reasonable doubt. It's still have difficulty with.
That's because there is no definition. Yeah, it is what is you believe to rise to that level. That if there is doubt, then that doubt, that whatever it might be that exists out there, is not a reasonable doubt. I mean, that's for you, each and every one of you, to determine. So I wish I could help you. I can't give you a definition, but what I want to know from you is, are you okay with that? And could you make a decision based on that?
I can make a decision, yeah.
And you can make a decision without having me prove to you with 100% certainty what happened?
Yes.
Same question for the next row, Mr. Graham, Mr. Andrews, and Mr. Alexander. Would you require 100% proof, or could you make a determination as to individually, as to yourself, what constitutes or gets me, quote unquote, over the hump beyond the reasonable doubt? Ms. Gerald, same question. Thank you. Mr. Wells.
I kind of have an issue of, it almost sounds like it's coming down to what I believe instead of what you can prove. And if you're not able to prove and you put out this general beyond reasonable doubt without a definition on it, then you're just sort of counting that I'm either going to like this guy or I'm not going to like this guy, and I'll make my decision on my own, whether or not you can bring the evidence that you bring forward.
That's fair enough. And thanks, Mr. Welker. You see how that works, ladies and gentlemen? He gave me his honest assessment of this particular issue that we're talking about, and there's no trap door that opened up that he fell through. He didn't get arrested by the bailiff, you know, and Mr. Welker, I'll say this, I am not asking you to make a determination as to whether or not you like this defendant or not like this defendant. What I will be asking the 6 of you who are chosen to be jurors on this case is to make that beyond a reasonable doubt determination based on the evidence of it. And if you think that evidence falls short of proving to you beyond a reasonable doubt, whatever that is to you, whatever gets you over that hump, then you make the appropriate determination. Does that help?
I can follow along with that, but that's where my head initially went with your.
Yeah.
Presented.
Thank you, Mr. Welker. Well, let me finish asking my questions, then I'll open it up to our kind of general questions. Wolf, Mr. Wolf, would you require 100% certainty?
No, because in my eyes, you're pretty much telling me you don't have 100% certainty. So in my eyes, you know, Tim, you're telling me that I've got to make a decision on pretty much evidence or something that's about to come out that we don't know for sure, or we're not 100% on. So I guess in my eyes, if you were in my seat, would you do 100%? Or would you require 100%?
Well, here's what I can say, Mr. Wolf, I'm just saying the law is.
I understand, but you're also telling us that you can't give us the definition of reasonable doubt. So,
Yeah.
That's hard for me to swallow, I guess you can say, because you tell me that I pretty much got to make a educated guess in my mind on whether or not this man is guilty or not.
Based on the evidence. in the court. Yes, and I think, again, I suspect Mr. Kimber is going to have a lot more to say about that when it's his turn. But again, I appreciate your honesty. Ms. Ferris, would you require me to prove the case with 100% certainty, knowing that that's not the legal standard? No, thank you, Mr. Ferris. Ms. Jackson? No. Overruled?
Yes, I'm under the impression that based off of the metrics you listed earlier, it can be proven 100%. We have socially agreed upon data and criteria, so I do think if necessary, a decision can be made, but I do think that it is the responsibility of the board and the justice to 100%.
You think it's the responsibility of the full justice court? I didn't hear that.
I think it's the responsibility of the court and in the name of justice to open up to be 100% if possible. If we have metrics that we all agree on.
100% if possible, and I'm sorry, I kind of have to pin you down on this, but knowing, you're saying if possible, but knowing that that's not the legal standard, 100% proof, would you hold me to that standard of 100% proof?
I think in this case, I would. We have in my metrics.
Let's go, we have 5 more minutes.
Thank you, Judge. Mr. Quinn, would you hold me to 100% certainty?
I'll be able to make a decision.
Thank you, Mr. Quinn. Ms. Branch? No? Oh, thank you, Mr. Now, make no mistake, there'll be evidence. I'm not suggesting that we won't bring you evidence in the state. But part of that evidence is not only physical evidence, it requires testimony relying on testimony of witnesses. And I just want to make sure that you understand that in addition to having the right not to testify in this case, in addition to having the right to be presumed innocent in this case, this defendant has the right for all the witnesses to start off on equal footing. And also get to you that just because an officer may or may testify or not testify in this case, don't give them any more credibility than you would any other witness, because it's not fair to this defendant, and it's the defendant's right to have those witnesses start off on the same footing. Does that make sense to everybody? Once you hear about that officer's training and experience, then you can give them all the credibility, all the weight to their testimony as you care to give that testimony. Okay. Is there anybody here who has had such a powerful or terrible experience as it relates to alcohol that they could not be a fair and impartial juror in this case? One quick example would be if your house was burglarized last night, Mr. Andrews, you come in here only to find out that this is a burglary case, you probably would have some strong feelings about burglary. So I want to find out from you guys if there's such a case instance with any of you, either you, your close friend or family member who has been impacted by drunk driving, such that it will affect your ability to be fair and impartial. Anybody on this first row, raise your hand if that's the case for any of you guys. Anybody on the next row, Ms. Johnson, Mr. Holcomb? Okay, we'll bring you up and we'll talk about that at the bench. Anybody else on the next row? Mr. Brown, Mr. Andrews, Ms. Johnson, Ms. Ferris, welcome. Sure. Gerald. Jensen. Bowling, Quinn, and Randall. All right. Does anyone know the defendant Cody James Patterson? Does anybody know his defense counsel, Mr. Wright Kimball? Is there anything that I have not said or asked you about as it relates to driving while intoxicated or DWI that you're sitting there thinking, man, I wish this guy would just only ask me this? I give him a earful. I let him. No? All right. Well, again, thank you for your time and attention. Not only is this an important matter for this defendant, but it's an important matter for the Jefferson County District Attorney's Office as well. We certainly do appreciate you taking this time out of your day and schedule to come here. Thank you.
Mr. Kimler, panel is yours. That's fine.
Mr. Kim and I approach really briefly.
Oh, well, yes. Yeah.
Well,
Hold on a minute. Yo. Okay, okay, ladies and gentlemen of the jury, I mentioned to you that the defendant Cody James Patterson is charged with a Class A misdemeanor, driving while intoxicated with an alcohol concentration level of 0.15 or more. Now, the range of punishment for that offense, a Class A misdemeanor, is confinement in jail for a term not to exceed a fine not to exceed $4,000 or both such fine and confinement. That is the range of punishment for a Class A misdemeanor in the state of Texas. Okay, so at this time, Mr. Kimler, are you ready to proceed?
Yes, sir.
The panel is yours.
I think Mr. Cohen just inadvertently mentioned Class B. Class A, that doesn't matter because you're not setting punishment, just for your total knowledge. I normally don't talk about myself in board hour, but since Mr. Coleman kind of briefly told me a little bit about himself, I'll just give you a brief synopsis of my history. I graduated in 1981 from Dayton University of Texas undergrad. And I'm sorry, I'll tell you a little bit about myself. I graduated from Neyland in 1981, went to the University of Texas undergrad, majored in philosophy, minor in Russian language, went to Leningrad State University for a summer semester between undergrad and law school. I was over there, decided to go to law school, basically kind of for the same reason. I guess you might say self-defense in a way, because I saw the government was running over people. And came back from the University of Texas Law School, came back here and been practicing since 1990, criminal defense.
So that's kind of my professional history, I guess. I did go back to the Soviet, or to Russia in 2019, did a semester at the higher school of economics in Moscow. See what's going on there, the idea of the situation currently. So that's really kind of my two interests, practice. I've always maintained an interest in what's going on in Eastern Europe, which is kind of topical these days, the situation with Ukraine, their war with the Russians. Yeah, I spent time in Ukraine too, back in 2014 and 2015. Speak Russian, keep up with stuff over there. Anyway, when y'all walked in a moment ago, and you saw Mr. Pass sitting at this table, anybody ask yourselves, well, gee, I wonder what this guy did wrong. What did he do wrong? Anybody? Mr. Wolverine, you ask yourself that? Yeah. Why is that? Why did you ask yourself that?
We're here, we're taking time out of our day to have this civil proceeding.
Well, it's criminal. Isn't it?
Yeah, criminal.
Criminal. Hopefully it's civil, not uncivil. It's a criminal proceeding. Well, why do you think he did something wrong?
We're here and faces flush.
Because he's faces blood. Good observation. Because he's accused of something, does that mean he's done something wrong? That he stands accused? Right. He's presumed to be innocent, right? Everybody's heard the presumption of innocence. So the fact that somebody's accused or even charged with something isn't evidence of guilt. Mr. Coleman talked about what evidence is. A charge itself is not evidence. It just gives the judge, in this case, a misdemeanor judge, the power to bring people in for jury duty, select 6 of them from the panel to constitute a jury, and jurisdictionally preside over the case. That's what the charge, not evidence of guilt. So right now, Mr. Passon is presumed to be innocent. So if you were to vote, Mr. Sokol, if you were to vote right now, guilty or not guilty, what would you vote, please? You don't know? Okay, think about it. Kind of a trick question. He's presumed to be innocent, right? Right now. Have you heard any evidence? So what's your vote? Guilty or not guilty? Not guilty, right? Because you haven't heard any evidence. And the presumption of innocence is there. So right now, if y'all voted, what would the vote be? Not guilty. All right. Does not guilty mean innocent? Ms. Ferris? Okay. What does not guilty mean? There's a defect in the state's proof, defect in the state's evidence. They haven't proved their case beyond a reasonable doubt, right? Mr. Cole was talking about certainty. If the state doesn't prove their case beyond a reasonable doubt, is there a certainty that Mr. Paxton is innocent? No. Doesn't mean he's innocent. It's certain he's not innocent. It just means that there's a defect. Some failure in their proof where they have not eliminated every reasonable doubt that you might have about the case. Right? Everybody follow? So the juries find people innocent. When you hear that, jury found him innocent. Is that accurate? Is it? Well, what do you think? Is that accurate?
No, they found him not guilty.
Found him not guilty. The juries do not find people innocent. Because again, certainty, you don't have that certainty. Now, I anticipate at the end of this trial, Judge Holmes is going to instruct the jury regarding proof beyond a reasonable doubt. In that instruction, he's going to tell you what it's not. He's going to tell you that proof beyond a reasonable doubt is not proof beyond all possible doubt, but only that proof necessary to exclude every reasonable doubt you may have about this case, something along those lines. So they're going to tell you what proof beyond a reasonable doubt isn't, but it's not going to be defined positively to tell you what it is. Mr. Sokol, does that kind of answer your question a little bit that you had? I mean, he's going to tell you what it's not, but not what it is. I think we've got a theology, I guess, I don't want to say student, you've got a degree, I suppose, right? What's one of the arguments? Being negative, right? The proof for the existence of God. You prove God by showing what he's not, and what you're left with is what God is. The via negative on the proofs. That's like proof beyond a reasonable doubt. It's the via negative. They're going to tell you what it's not, but they're not going to affirmatively define it for you. How do you say it? Bulgarian. There used to be a definition that was given for years in our courts, and it was proof of such a convincing nature that you'll be willing to rely and act upon it without hesitation in the most important of your own affairs. And that was the definition. So for years, I'd argue in front of a jury, you hesitate in believing the state's case? Is there hesitation? Well, that's reasonable doubt, because it's defined. Well, a few years back, the Court of Criminal Appeals issued a decision that said, we're not going to use that definition. We're not going to define proof beyond a reasonable doubt, because it's within the competence of every juror to decide what it is for themselves, how high of a level of proof that is, knowing that it's not proof beyond a possible doubt, but within that parameter, the juror, the individual juror gets to decide how high the burden. Now, does that help you, Mr. Lorraine? So this idea of certainty, that if a jury finds somebody guilty, is that 100% certain that they committed the offense?
It should be,
Is it?
not necessarily, no.
Right. Are there people who have been convicted under that standard who have later been exonerated, whether through DNA evidence or whatever type of evidence has shown that they actually were innocent? Right? If there were certainty, if that guilty verdict meant certainty, you never have people who were wrongfully convicted. So it's not certainty. It can't be certain because you're not there. You didn't see it happen, right? You can't be 100% certain. That's the trick. If you were certain, you would have seen it. You're a witness. You can't be a juror. But I would suggest to you that you perhaps are on the right track, that it's a high burden. Obviously not impossible, but indeed a difficult burden of proof, because what you're talking about is whether somebody potentially could be put in jail. Out on Highway 69, I'm sure y'all have all driven past it for up to a year. Now, how certain would you want to be about that? How certain?
Very certain.
Not 100% certain, but
99.
90. Don't have my names down here that well, Mr. Let's see. Gendry? Yeah, Mr. Gendry, what do you think proof beyond a reasonable doubt is?
The evidence for me to believe that he's guilty or innocent.
Well, he starts out as innocent. So right now, is he innocent or guilty?
Yes.
He's innocent. Do you think that the type of evidence that you would need would be something that you wouldn't be second guessing yourself the next day? You'd be comfortable with that when you got up in the morning the next day and looked yourself in the mirror and that you made the right decision? Is that fair?
Yeah,
You don't want to second guess yourself?
correct.
What do you think, Mr. Foster?
Yeah, I think the same.
Okay. What, I noticed on your information sheet, I guess you're a trader, commodities or FX or Forex.
I'm an institutional prop trader.
I'm sorry?
I'm an institutional prop trader. I trade currencies.
Currencies.
And commodities.
What level of certainty do you need before you push that button and execute the trade?
You need to be 100% you think you're gonna get it right. But
Do you know you're gonna get it right?
oh, absolutely not. That's why you manage your risk.
You hedge your risk, right?
Yeah.
So you make an offset trade that would hopefully take account of the risk that you're engaging. How would you base your decision on how to define reasonable doubt as a juror, based upon your experience in executing the trade? How would you do it? How would you do it?
I would try to be as certain as possible to actually push
What would you look at
on my,
on their case, on their evidence? How would you evaluate it?
the evidence they present.
Well, you know, Mr. Coleman talked about people slurring their words or not saying their, I think he said ABC. I mean, would you look for alternate reasons maybe?
Absolutely.
And maybe not take things just on their face value?
Exactly.
What do you think, Mr. Indy? Proof beyond a reasonable doubt, how high of a burden is that?
It's a high burden.
Okay, not impossible, we know, right?
Yeah, not impossible.
Why do you think it's a high burden?
It's a high burden, but it's, so as a reasonable person who, you know, you get up in the morning, you go to work, you dress yourself. I think everyone can judge what is
reasonable. It's hard to explain what it is, but it's high. And like you said, when you get up the next day, you don't want to second guess it.
Exactly. Okay.
Doable.
And again, it's not impossible. People are convicted every day
Right.
on that standard of three. So while difficult, it's not impossible. But, this, Johnson, what do you think? Proof beyond a reasonable doubt. Johnson?
Yeah.
Yes, ma'am. What do you think? Proof beyond a reasonable doubt. Don't know? Well, do you think that if you're a juror in the case, you're gonna have to decide whether the state's met their burden of proof beyond a reasonable doubt? Can you do that? Man,
Honestly, I hope I'm not.
okay, do you want to be excused, I guess?
I don't have the right excuse.
Okay, is there something that we can take up with the judge?
No. I just don't want to be talked to.
Okay, I'll leave you alone. Fair enough. I'll just tell you this, why did you come?
Have to.
No, you don't. If you don't show up, nothing's gonna happen.
Yeah, I'm looking for you.
I believe stand, there's nothing gonna happen. If you can stand up and say you're gonna be arrested or have a warrant issued.
Objection, Your Honor, I did interrupt this, board hour examination. That's a misstatement of law. There are potential consequences.
It's not a misstatement.
For not showing up.
It is not a misstatement of fact in this county that if they don't show up, nothing happens.
Okay.
That's not a mistake.
Oh,
Misstatement of law.
okay, objection sustained. Mr. Kimberly, you may move on.
I'll represent to you, man, that nothing's gonna happen if you don't show up, whatever the law is in this county. That's not a misstatement of fact. Would you still show up? Or not, knowing that nothing's gonna happen to you?
If it says you have to, I will.
What about you, Mr. Alexander? I noticed on your information sheet, I'm shifting topics here, by the way. This is not the only reason that that was something else. I'm not as organized as the prosecutor. I noticed on your information sheet, you said that if you didn't think you had to be, I'm paraphrasing, that you wouldn't be. Right?
I don't like the idea of being summoned virtually to the concert.
Okay,
In some cases, I feel like it's a waste of my time,
so why do you come?
because I got a summons, and I prefer to try to keep my nose clean and not risk any kind of legal consequences.
So if I told you that nothing happens to you if you don't show up,
I renew my.
Objection.
I renew my objection.
I'll have your word over.
well, I'm gonna, Your Honor, say that I'm gonna object to the objection because I have a right to proffer questions that are reasonably calculated to lead to the proper exercise of peremptory challenge. And that question is being formulated in that.
Well, I think his objection, now, Mr. Coleman, would you state what your objection was?
That there are potential legal ramifications for not showing up for jury duty. And what he is doing is he's misleading this jury and misstating the law.
I challenge Mr. Coleman to point out anytime in this county, anyone has got.
Mr. Kimler. Okay, you have to have a legal response to his legal objection.
My legal response is a statement of fact. It is not an untrue fact. It is an affirmative, truthful assertion of fact that in this county, if you don't show up for jury duty, there are no adverse consequences.
Your objection, Mr. Coleman, is sustained. Mr. Kimler, move on.
Why is it important to show up for jury duty? Yes, ma'am.
Do your civic duty.
Okay, so
It is-
why do we have that civic duty?
To me, it's an honor and a privilege to be able to be counted as one that may or may not see the reasonable or unreasonable doubt in a case.
What are the consequences of a criminal conviction? The possible consequences.
The possible consequences in this case would be that he could serve up to a year in jail.
In any criminal case, can somebody lose their freedom?
Yes,
What's the most important thing in your life?
freedom.
Kids, other
My
things.
children,
Freedom's up there, right? Locked in a cell, having every decision made for you. What clothes to wear, what food to eat, what time to get up, where to go, who to go with, every decision that we make is free people taken away, right? Door clicked shut at night, claimed shut. Bars and cold gray walls. trained whistle. I mean, you get the idea, right? And I don't need to try to be humorous here because it's not a humorous situation. Who makes that decision, whether somebody's criminally convicted in our system? Yeah, everybody, who? The jury. Why do we do that? Why do we allow juries to make that decision? Or require, not allowed, require. Why not? Wouldn't it be a lot easier? We wouldn't have to bother Mr. Alexander, we wouldn't have to bother Ms. Johnson with jury summonses. Just get rid of the jury. Right? Ms. Johnson, we get rid of juries? We just get rid of them? Ms. Doggett, you want us to get rid of juries?
I'm not convinced that it's always a very good system.
Why? What's the alternative? All right, let's go get, we got Judge Holmes here, we can go get Judge Stevens and maybe Judge West, we can have 3 judges listen to the state's evidence and just not bother people. Why don't we do that? Anybody, why don't we, Mr. Welker, why don't we do that?
Inherent biases that may happen between relationships that people may already have in the system. Bringing a jury in at least gives you an opportunity to make it a little bit more fair than what the system already is.
What's your name, sir? Sorry.
Mr. Andrews,
Andrew, what do you think?
impartiality.
Impartiality.
Theory of your peers is from all walks of life and all backgrounds and doesn't have the same biases that the judges might have.
What about you? What's your name?
Now,
Sorry, what do you think? Why do we have juries? Why not have 3
you get
judges?
different views. It's not just 3, it's a different set of people each time, it's a different mindset, it's a different thought process.
So you get a more accurate result.
You get a
All right,
more widespread.
Mr. Quinn, what do you think?
The people get this time.
The people, right? The people. Do we let the government decide? How many people here trust the government? Not certainly. That's absolute certainty. We trust the government. Anybody? Right? And again, I like the Soviet Union, Russia right now. You think they have juries for people that are protesting against the government? Even though they put that in the Constitution, they just take it out of the way. You go out, you have an illegal demonstration. Because a jury get to decide whether you're going to the penal colony in Siberia. No, it's the government. What are judges? And I'm not putting this judge on good or any other judge. That's still the government. That's the importance of the jury system. Even in cases like this, with just the DWI. That's why it's a sacred responsibility, sacred power, because the power to convict and deprive somebody of their liberty doesn't rest with the government in our system. It rests with the people as long as we have juries. So that's my take on it. So let me move on. This is a DWI case. Obviously, there's been some rather horrific intoxication manslaughter cases in our news recently. Has anyone here ever had this? Colton kind of asked this question about alcohol, but had a loved one, family member, close friend who's either been killed or injured by an intoxicated driver?
Yeah.
Mr. Loco, anything about that experience you think that might affect your ability to be fair and impartial?
Very comfortable to say.
So I'm sorry. Okay, you want to just address that? Okay. Anyone besides Mr. Soko maybe had an experience that may affect their ability to be fair and impartial? Okay. All right, anybody have any questions of me? Because I'm about to give you some time back. No? Other than Mr. Soko, does everybody feel like they can be fair and impartial? DWI is not complicated. Yes. All right, there you go.
Ladies and gentlemen of the panel, we're going to ask that you would follow the bailiff outside. We may call some of you back in for follow-up questions. So at this time, the court will be in recess to give you an opportunity to follow the bailiff to the hall.